Good afternoon. My name is John Tierpak, Program Director at the Unemployment Law Project. Today we have Ann Paxton, our Policy Director, who will update on current events with the unemployment law, and also we will be able to take your questions. So Ann, would you like to proceed?
Yes, thank you, John. So I wanted to start today. Thank you for tuning into our webinar. Just to announce that the Seattle Times did a story about the anniversary, basically, of this huge slam to the Washington State economy and to Washington State's 3.8 million workers. When a year ago, when all of the unemployment started and this huge surge and people started applying for benefits. So this is a chart that the Times ran to show around the middle of March, the third week in March, when it really spiked. It went up to about 126,000 a little over a year ago, and then it went to a record 181,000, which was pretty amazing. But that was, so a year ago was what was really the first time, the first solid signal for what was going to happen to the economy. It was 5 times the number of jobless claims as were filed during the Great Recession. And everyone knows what's happened since then. So it's interesting to look back. Things are a little better now. It was February 28th of last year that the King County reported the first known COVID death in the country. And that after that, the mass layoffs started. Governor Inslee called for closure of all non-essential business locations, and many layoffs followed that. And another report in the Times this week was about the level of jobless claims, where they are today. So their unemployment claims are continuing to drop at a sort of slow rate, but they're down again over the last week. There's signs of recovery. There were about 11,300 new claims filed. That's a 2.6% decrease from the previous week. And there were 24,500 new jobs added in February, which is the largest monthly increase since August, when the economy was starting to recover significantly. A lot of those were in leisure and hospitality, which is understandable given that the restaurant and hotel industry is starting to open up more. So the jobless rate, technically, these are technical numbers, 5.6% now, as opposed to 6% in January. That doesn't mean a lot when you don't have a job, but that's what the technical number is, and it's kind of important in terms of getting our benefits authorized by the feds. The state labor force, as I mentioned, is 3.8 million, and that's still 124,000 less than it was a year ago, a little over a year ago in February. So there's still a lot of ground to cover. But everyone may remember that it's been a normal year of unemployment benefits is about $1 billion paid out by the Employment Security Department. Over the last year, ESD has paid out $16 billion, and 2/3 of that is from the feds. And that's gone to about 1 million Washingtonians. The big news this week, however, is that the legislature is winding down, and in the process, they have voted through the committees our bill SB 5193. That is a significant bill that would improve claims processing. So we've been working on this for quite a while. It started out to address a big sweeping range of claims processing issues, and it's still, many of those survive. There's quite a lot of process that goes through when these bills are introduced, and different legislators get a chance to weigh in. But they've been okay. These provisions have been okayed in the Senate Labor Committee. They've already been cleared by the Senate. A slightly different version, a better version, has been cleared by the House Labor Committee. So now that that's happened, the bill is scheduled to go to the House floor. So it should be voted on. We're very optimistic it's going to get a yes vote. Then it will go to the Senate because of the differences in the bills. Those have to be ironed out. But this would provide quite a lot of protection from a lot of the dead ends and delays that people received when they applied for claims, when they filed claims over the last year. What it does is it starts a training program for adjudicators that would be creating a reserve pool of the faction of the labor force at ESD, which was seemed to be in very high shortage. And that was one reason why people's claims languishing in adjudication seemed to be there for quite a long time. Really important provision is the use of plain language tested on claimants for comprehensibility for all letters, notices, and alerts. The determinations that people receive, the decisions, will have to be spelled out in terms of the statute number, an explanation of the law, and then something that the ESD used to do before it got its new computer system in 2017, and that is clearly explain the facts of the case, what happened at your job separation, for example, and what your employer says, the reasoning for the decision and the result. Some reforms that we would have liked to see have remained in the bill, but they're in terms of exploring them as possibilities. One is automatic thresholds for adjusting staffing so that when a certain number of claims and calls starts coming in, staff levels would have to increase at a proportionate amount. Another is a pilot of a caseworker approach to benefit claims so that you would have an assignment of one person to work with in the claims processing unit. And increased language access. We had hoped to get automatic translation of all the notices and letters into the top 10 languages spoken in Washington. And that did not make it through, but we're hoping that some preliminaries to that particular reform actually start happening. Toll-free number for claimants who have limited computer skills or access to computers. And right now in the House version, fairly expansive data dashboard, which would include not only the standard information about claims and the number of claimants there are, and also the unemployment rate, but also claim center phone statistics. That is, how many people are calling, how many people are on hold, and what is their average hold time. And that would have to be reported regularly, so there would be a basis for comparison between slow periods of low unemployment and periods like the current one where there's a high level of unemployment. And then staffing ratios would be included in that, as well as the number of claims that are pending in adjudication, number of claims that are being held, appeals that are being held up, data about overpayments, and some other information. And that would be reported quarterly to the legislature. So we're hoping that this is a kind of an accountability measure, a public transparency measure that will help encourage some faster processing than we've seen over the last year. So we're encouraging everyone to contact your legislators and request their support for this bill, SB 5193. And I think Erin O'Brien, our legal assistant, was going to put that link, or has that link, if we can get that in the chat box, which I don't have open here. So you can go to your legislative district finder, and you want to write to your House members. This is called Senate Bill 5193, but it's called that in both houses, in both chambers. So you want to ask for their support for 5193 when it comes to the floor. Very important bill. Also wanted to mention a new Department of Labor website on the issue of identity fraud, which continues to be something that is affecting a lot of Washingtonians. So this is something you may find out about because you've gotten mail from the Employment Security Department about an unemployment payment that you did not receive, or you didn't recently file for unemployment. And sometimes these might include unexpected payments. So if you get something on your debit card that you don't recognize, that's a good sign that there may be something going on with identity fraud. Or you might be getting these 1099-G tax forms from the state. Those you should not, if that's income that you did not receive, you should not report it to the IRS. They've made that very clear when you file your taxes. But you do want to get the state to straighten it out. So you need to contact Washington State to fix it. You may get a notice while you're still employed from your employer showing that they've gotten a request for information from ESD. That's another bad sign of identity fraud. So, but here's the Washington State page to go to straighten out any situation where there's an imposter posing as you. And the Department of Labor website is here as well for this new information about how to handle identity fraud. And then finally, just to mention, again, oh, I wanted to add, there's one piece of news that I did want to mention. Earlier, I discussed a little bit about the Office of Administrative Hearings. Those are the judges that handle hearings when people appeal. And we've seen significant delays of months for people getting those hearings scheduled. But in the last, over the last month and a half, the office has written to the legislature to say it's going to be so much worse. They've projected a current backlog is about 30,000. They're projecting a backlog of 70,000 and a wait going up from 3 or 4 months now to 23 months. So when they wrote that to the legislature, they did get some attention, and we believe that they are now slated to get their $22 million budget increase, which will allow them to hire more judges and avoid this really unbelievable length of time to get a hearing scheduled. So an added note there is, if you know someone who's interested in being an administrative law judge, there are a lot of openings there. They're looking for ALJs, and they will definitely read your resume. Again, I just want to mention, if you need a very handy, pithy, and fun resource for finding out unemployment, anything about unemployment benefits, a whole range of topics, basic guide, and also updates on the new rules and laws. These are some of Lavina's links, and I think Erin has the link for her general TikTok page. Erin, I just wondered about the question about the other site, the what was it? another format for TikTok.
Yeah, to answer your question, Anne, Lavina also is starting to share some of these TikToks on an Instagram page for the Unemployment Law Project. The link for both the TikTok and the Instagram is linked below, so you can watch all of their videos there. Yeah, so basically TikTok, Instagram should be able to access those videos in both locations.
Thanks, Erin. So that's the news for this week.
All right, thanks, Anne. Now we can take some questions. I'm putting my name and contact information in the chat just because at some of these meetings or webinars, sometimes people have questions that are very personal, or questions that should better be handled in a one-on-one consultation. So I put my contact information in the chat. So we have a few questions already. The first one is an inquiry about how SB 5061 might help a certain situation. It's a high-risk individual who has been at home since April getting unemployment benefits. The employer is an office which would have constant contact with the public. And the employer is now insisting that they return to work now, or they would be replaced. They are unable to commit to a time frame at this point. And so the question is whether this person is able to resign and continue to get unemployment benefits under this new bill or any previous bill or proclamation. And if so, is a person able to resign immediately, or is there a specific date that SB 5061 will take effect? So Anne, could you handle that first, and then I'll give my opinion.
So SB 5061, I don't have the exact date. It might be already in effect. I'll have to get that date for you. But that unfortunately does only apply to offers of work that a person would decline. So it affects your availability for work, but it does not yet allow a person in itself. It does not allow people to quit a job that is unsafe because they have a high risk situation themselves, or they live with somebody who's high risk. If you receive a job offer and turn it down because of those reasons, that should be covered by Senate Bill 5061. But voluntary quits are a different issue. There is room to quit a job if there's a safety issue. That's already in Washington state law and in federal guidelines as well. And not every state has that exact provision, but it may be, it's something that you need to demonstrate to ESD, and they may not grant your benefits right away. You may have to appeal before the Office of Administrative Hearings.
And so in all these cases where a person may quit, under the current law, it requires you to exhaust all of your possible remedies before quitting. Like, for example, a medical leave of absence, requesting accommodation, getting formal medical information to the employer, making this official, and having a paper trail before quitting. So general advice in these situations is not to quit if they fire you and you have a good reason for not coming in, such as a medical or safety issue that may allow you to get benefits. But I would suggest that you contact me individually for a more detailed conversation about this, because it's a very difficult issue, and we see cases that go both ways, and it's hard to just give a straight up or down, yes or no opinion about what is best in your case. But getting medical documentation first off is a very good start. Okay, so we have a actually, it's not so much a question, a comment from someone who tried to file their weekly unemployment claim by phone, and they tried twice, but the system went through several questions saying to your claim, without saying to file claim press, and there was no option for that. But this person was able to file online through their SAW account. Well, that's good news that they were able to get through. I haven't heard any particular problems with the filing by phone. I know the systems have their ups and downs, both the online system and the phone system online. I guess what I'm getting from this is if anyone else is having trouble or knows someone who's having trouble with the phone, to go to the online account and make the claim there, and it will probably be successful. But the systems have had their ups and downs for quite a while. Let's see, let's go to other questions here. This person's appealing a denial of regular unemployment and waiting for a hearing. Can I apply for PUA while the appeal is pending and waiting for hearing? Or do I have to wait till after the hearing? This is a big issue we've been seeing. A lot of people are being told, and I don't know where this is coming from, but they're being told by employees at Employment Security that they must appeal their regular unemployment denial in order to get PUA. That should not be true. So I would urge a person in this position to file for PUA, follow up with PUA. If they're not processing the claim, call your state senator, your state representatives, and the governor's office and tell them you were denied regular PUA and that you were denied regular unemployment and should be eligible for PUA. Now, if your hearing comes and this hasn't been resolved, you can ask the judge at the hearing, if you're not successful getting regular unemployment, to ask them to look at, or the remand is the language, to look at the PUA. We have talked to people who waited for many, many months who finally get their PUA when they finally do have a hearing and the judge formally does deny them the regular unemployment as it was denied for months, and then remands it for the PUA application, which is then often granted, not always, but often granted. Anne, do you have anything to add?
Yes, I wanted to mention something that we've just realized, which has been a real problem for people. In addition to the fact that there are employees giving out this misinformation, it is not true that you need to appeal a denial of regular benefits. And if you do appeal, you may be able to get a hold on your overpayment, but you do not have to wait for the resolution of that to apply for PUA. So you should get that PUA application in process as soon as you can. The requirement, the baseline requirement for PUA is to be rejected from regular benefits. So in some cases that might be to your advantage. The problem is that people are being, in some cases, switched from PUA to regular benefits, and they're not getting an actual decision that they can appeal. There is no piece of paper or form that says you have been switched, because they have a different process. You actually go through this potential new claim, reapply for a new claim. So what does that mean? It means that people are appealing their regular benefits denial when they really want to be appealing. They really want to be appealing a PUA, their switch from the other program, that they should have been in PUA. It's very confusing, and we're trying to get in touch with the Employment Security Department about fixing this, because it's really a problem when people they get a ruling from the Office of Administrative Hearings and it doesn't help them. So it's because it's the hearing ended up being about the wrong decision. We're working on it.
Thanks, Ann. And here's a question for you. If SB 5193 passes, is there any indication how they would create the pool of reserve adjudicators? Would this create new jobs, or would this just mean cross-training of existing employees?
No, this should be potentially new jobs. That doesn't contain actual numbers, but this would be a new training program set up so that these people would be, a lot of them having outside and different jobs, or having a schedule that would permit them to, if there were an emergency, such as we experienced over the last year, to move in quickly and need minimal training to get up to speed and be able to work as an adjudicator right away, because there has been a big lag in terms of the training. So the numbers aren't there, but these would be additional people from the outside. So there should be many jobs when this passes.
All right. Thank you, Ann. So it looks like there are no more questions right now. Let's wait a minute or so and see if there's additional questions before we wrap up today. I'd like to thank Ann and thank Erin for running the webinar, and thank all of the participants so far. It's been quite a year for the Unemployment Law Project. We've had many challenges, but we are representing people at hearings, as many as we can, and are doing our best to work with people both on an individual basis, but also advocate for changes at ASD to try to solve these problems that have gone on way too long. So yeah, I'm not seeing any more. Oh, here's one more. Oh, here's a couple more. As a substitute instructional assistant for public schools, they're now asking us to come into the school, but I have not had all vaccinations and do not want to have to move furniture. I'm not sure what that means. Do you have to do this to keep getting unemployment? Again, this is a similar thing about, being asked to come into a potentially unsafe or high risk situation, similar to the other question. Specifically, there are things you could do, like get a doctor's note saying why you can't come in, explaining why you're high risk, requesting a medical accommodation to be able to continue to work from home, maybe taking a leave of absence. That there's a number of things that can be done. I would not, of course, I would not advise quitting under these circumstances, but to keep them informed about your willingness to be able to accept suitable work. And you have anything to add?
Yes, and this is covered by SB 5061. So if you're in a high risk category, and that could include a lot of people, if you're over 65, or if there's work that you have a medical reason that you shouldn't be exposed to it, then you should be covered. That took effect in February. So this allows you not to have to return to work if you are personally at high risk, or you're residing with someone who's at high risk and should not be exposed.
Okay, so there was a further comment that the setting up furniture was for getting the school, the school thing. This person's adding a lot more questions. I would urge them to contact me to correctly. I put my phone number and my email in the chat. I have a further question regarding help with waiver requests and whether UOP helps with that. Yes, we can give advice on filling out a waiver form if you have it. If the overpayment hasn't been remanded for waiver, that can be a chore, a difficult task to get it to that point. Often people are denied waivers and request the hearing, and of course we've represented people in those hearings when we can. So it depends on where you're at, but I would urge you to contact UOP or me directly if you have questions on waiver. And just in general, waivers when there's an overpayment and the overpayment's eligible for waiver, the claimant's not at fault for the overpayment and there's a hardship to repay. So generally what they do is often it comes out of a hearing decision that goes against someone, and the judge will say the issue of overpayments remanded back to employment security. The claimant should get a questionnaire asking about their income, assets, and expenses and other circumstances. That should be processed. If it's in their favor, great. If it's not, they could have a right to appeal to talk to a judge more about what their hardships are, for example. So there's the waiver process can drag out, but it has been successful in many cases because very often these overpayments are not the fault of the claimants. And of course, in many cases, there would be a hardship to repay. All right. Any other questions? Okay. So there was a follow-up to the person with the issue with filing. I just said that we haven't heard of any particular problems with the phone filing system, but it was good to hear that you can file with the SAW account. And so I think that would be general a good recommendation. If anyone files by phone on a regular basis and they can't do it or can't get through, to go to the e-services SAW account and make the weekly claim there as soon as possible. All right. Any other questions before we wrap up? Okay, I'm not seeing any. So I'd like to thank everyone, and we will be back next week. Thank you very much. Thank you.
Bye. Thank you.